Some intended parents will be able to be legally recognized without going to court. It's going to be less expensive for them. It's going to be an easier process. But that's only, of course, the case where both the surrogate and intended parents reside in Quebec and they very carefully follow the rules that are set out for them. My name is Stephanie Carsley. I am an assistant professor at the University of Ottawa's Faculty of Law, English Common Law section. Much of my research over the last decade or so is focused on surrogacy. So these are situations where someone carries a child for someone else. So the article I published in the Revue Générale des Droits focuses on some very recent reforms to Quebec surrogacy laws. At the time I wrote the article, these were proposed reforms. They've since been enacted. Prior to these reforms, there was just one provision in the Civil Code, Article 541, that responded to surrogacy. And this stated that surrogacy agreements are absolutely null. So it meant that, for instance, a surrogate would not be bound to give up her parental rights with respect to a child on the basis that she signed an agreement. And because the code was otherwise silent on surrogacy arrangements, this meant that default family law rules applied. Where a surrogate gave birth, the surrogate would be recognized as a child's legal mother pursuant to the law. And in order for the surrogate to give up her parental rights or for both intended parents to be legally recognized, they actually had to go to court and apply to adopt the child. And so lawmakers sought to clarify the law, also to make it easier for some intended parents to be legally recognized. And at the same time, they sought to regulate the practice of surrogacy to ensure that the new laws responded to some of the concerns about potential harms around surrogacy. Article 541 of the Civil Code was repealed, and this was replaced with 37 new code provisions that seek to regulate and respond to surrogacy arrangements. So the general rules that apply to all surrogacy arrangements, one is that a surrogate needs to be over the age of 21 and cannot be paid or remunerated for engaging in surrogacy. And the second set of rules apply and are a little bit different depending on whether the surrogate resides in Quebec or resides outside of Quebec. If she resides in Quebec, it's going to be easier for the intended parents to be legally recognized. And effectively, they can be recognized as the child's parents without going to court, without obtaining an adoption, provided certain conditions are met. The intended parents and the surrogate need to have an independent meeting with a counselor or another professional prior to entering into a surrogacy arrangement in order to obtain information about the surrogacy process. They need to also enter into a notarized surrogacy agreement prior to conception. And the surrogate needs to consent following the birth to give up her parental rights, and this can happen no earlier than 7 days following the birth. If the surrogate is living outside of Quebec, there's new additional rules that will apply. The intended parents need to apply for ministerial approval prior to engaging in their surrogacy arrangements. They need to go to court in order to be recognized as a child's parents following the birth. And in addition, the government has recently indicated through regulations that there's only 7 provinces in which Quebecers can work with a surrogate. I think that there's certain elements of these reforms that are a missed opportunity. I had hoped that the government would go further in regulating surrogacy contracts. Sometimes these contracts contain clauses that indicate what the surrogate will and will not eat during pregnancy, that seek to dictate potentially her reproductive choices. And sometimes these contracts also contain clauses that indicate that if the surrogate breaches the terms of the agreement, then she might have to repay money that had been paid to her for her reimbursements. We have case law in Canada that indicates that these kinds of provisions around a surrogate's behavior or reproductive choices would clearly not be binding on the surrogate. But I worry that because these kinds of provisions are in a surrogacy agreement, that surrogates or intended parents might believe that they're binding just by virtue of being in a legal document. The government does kind of set out the kinds of provisions that should be in these notarized agreements. They also indicate that any sort of penalty clause cannot be included. But what I had hoped that they would do was actually say, these contracts really should only contain clauses that could actually have legal weight. Who intends to be the child's legal parents, and what kinds of expenses the intended parents agree to reimburse the surrogate for. One of the elements of these reforms that I think will ultimately not support lawmakers' objectives are these restrictions around cross-border surrogacy. One of the things I saw from my empirical research is that surrogates are making decisions about who to carry a child for, sometimes on the basis of their location, but much more often on the basis of either fits or the fact that they know the person. I'm not so sure that these restrictions on cross-border surrogacy are actually protecting surrogates. I think they're potentially putting them in a more precarious position where they're not necessarily being able to give birth in the hospital of their choice, and they're potentially traveling just prior to giving birth in order to ensure that they're not giving birth in Quebec.